Well, I'm seeing that the number of participants is growing very fast here. So welcome everybody to our webinar, a part of the Canadian Trademarks series. As people are joining us, let me introduce us. My name is Christian Bolduc. Together with my colleague Francesca, we're going to be your speakers today for the presentation. And we're going to be talking about a very hot topic in Canada right now, the French Charter and Bill 96. I am being told that I have to mention a few things to you before we begin. The presentation will last about 45-50 minutes, depending on the number of questions that we receive. We will take your questions as we go along, so please do type them in the Q&A panel, not the chat, and we'll try to address your questions again, as I said, as we go along. The webinar is recorded, and also at the end, there will be a pop-up survey that hopefully you'll be filling up, because any feedback is good feedback. So with all this, we will begin the webinar. So today we will be covering, as we said earlier, the French Charter. So the Charter of the French language that we'll refer to as the French Charter, and Bill 96, the recognized trademark exception, the changes to come under Bill 96, those that are not yet in effect, that will change the trademark exception. We'll cover some ideas on how to prepare for what is to come. And the Q&A is, as I said, as we go along. And of course, if there is time left at the end, we'll also be taking questions at that time. All right, so the French Charter and Bill 96. So the French Charter is a statute that was adopted by the Quebec government almost 50 years ago. And it aims at protecting the French language in all spheres of life in Quebec. The rationale behind that, because I think it's important to discuss that, is that Quebec is essentially an enclave of French speakers in the Canadian landscape, and people would kill me for saying that, because there are French-speaking people elsewhere, but I would say that there is a large concentration of us in the province of Quebec. And, you know, over the last decades, the prevalence of French language has been going down, and that's probably one of the rationale for the Quebec government, as we'll see later, to adopt Bill 96. So the Charter deals with the courts, it deals with businesses, it deals with all kinds of things that affects people. And so we'll move to the next. Bill 96 changes the French Charter in many ways, again, to reinforce it further, to better protect the French language in the province of Quebec. So with sanction on June 1st of this year, there's major revisions. The complaint process is significantly revised. It used to be that people would file a complaint and they wouldn't hear about it anymore. Now there's a feedback process incorporated into the complaint process, so that people who file complaints are going to be advised of the progress of the complaint. So that's completely new. The Office québécois de la langue française, which is the body which is responsible for enforcing the French Charter in Quebec, has increased powers, notably the power to issue injunctions and force people to do certain things, or to remove products or signs, as we will see. The fines are significantly increased, and those changes affect significantly, again, work, education, commerce, and the courts. Well, for those who do not know where Quebec is in our beautiful country, it's in red right there. And red doesn't mean any political thing here, for those who understand what I'm talking about. As you see, the flag of Quebec is blue, but we've put the province in red. So we're making everybody happy here. And so what we're going to be focusing today on is the language of commerce and business. So we're going to be talking about product markings, documentation. We're going to be talking about advertisement, and we're going to be talking about outside signage on building. With that, I will let my colleague Francesca take it away.
Thank you, Christian. So I'll give you a brief overview of the current general rule with regards to product markings, commercial publication, and public sign and advertising. So the general rule under the French Charter is that markings on product, including their container, label, and wrapping, as well as their accompanying documentation, and we provide here a couple of examples. So this can be certificates of warranty, user manuals, brochures, promotional materials, and so on and so forth, must be in French or in French and another language, provided that the markings in the other language are not given greater prominence than the markings in French. So what does that mean in practice is that any other language can be equal or less predominant than French. And this requirement will be assessed in terms of visual impact. So not only in terms of the size of the markings in French compared to the size of the markings in English, it could be also in terms of their positioning, their color, their font, etc. So when several languages are planned to be used and there is a space constraint on the product, it may be important to work upstream with the marketing team to determine a strategy for the Quebec market. In addition, any other language than French must not be available on more favorable terms. An example here would be a user manual available in English and in French, but where the French version will be a translation of mediocre quality. We can also think of a product package in a box having sides with different languages. So for example, 2 sides of the box in French, 2 sides of the box in English, but where one of the side in English would be clearly designed to be the front panel of the packaging. So in that scenario, obviously a consumer entering a retail store would most likely see the English side of the packaging at first, given that the box would be placed on the shelves in order to put the front panel in front of the consumer. So as such, the French markings would be less visible. For commercial publications, the general rule is the same. So they must be in French or in French and in another language, provided that the French is not given, the other language is not given greater prominence than French or be available in more favorable terms. Commercial publication includes brochures, flyers, catalogs, and it's important to note that according to the OQLF, commercial publications also includes websites and social media. And for websites, it's all the websites content that must be available in French. So not only the substantive content, but also the Q&A sections, the terms and conditions, the privacy policy, or any other purchase agreement. However, there are nuances to this general rule in that commercial publication can be published as 2 separate versions, one in French and one in another language, provided that the French version is as accessible and of the same quality as that in the other language. So in that regard, you must be careful with online translation tools, as the results may not be compliant if the quality of the French version is questionable. And as shown here, a good example of a bad translation with an online translation tool would be to translate "made in Turkey" by fait en dinde. So in French, dinde being the bird that we eat at Christmas rather than the country. For public signage and advertising, the rule is that any message displayed in a place accessible to the public, regardless of the medium used, so it could be signs, posters, or billboards, must be in French or in French and another language, provided that the French is markedly predominant. So according to the regulation under the French Charter, the markedly predominant requirement means that the text in French must have a greater visual impact than the text in the other language. So for example, if we have a text in French and its corresponding text in English that appear on the same sign, the space allocated to the French and the characters of the French must be at least twice as large as those of the text in English, and the sign itself must not otherwise reduce the impact of the French language. When there are separate signs, for example, some in French and some in English, those in French must be twice as numerous as those in English to satisfy the markedly predominant requirement. And Christian, I'll let you continue here.
Thank you, Francesca. So for those who attended this webinar last year, as you see, we're covering again the same basic principles so that we can highlight the differences that are introduced by Bill 96. So we're going to go a little bit faster on those, especially for those who've already attended this webinar last year. So the recognized trademark exception. So what is that? Well, a recognized trademark does not need to be translated into French, provided that the French version has not been registered in Canada. So first takeaway from this, and that's an important one, is that you can use French versions of your trademark if you want, but we would say that normally, unless there are some significant incentive to do so, it's preferable, at least from a language perspective, if you don't want to be forced to use French in Quebec, to not register the French version of your English worded trademark, essentially. And what is it, a recognized trademark? So it's important because, as you will see later, this is being changed by Bill 96. So it's either a registered trademark in Canada or a common law trademark in Canada. So we're going to be explaining now what those are a little bit more in detail. So what is it, a registered trademark? It's a trademark for which a certificate of registration has issued. So it's not a pending trademark application. It's a trademark that is registered. The benefit of registering your marks in a language other than French is that it allows a resolution of any complaints that you receive from the QLF in a very, very easy fashion, as we will see a little bit later. As for common law trademarks, it's a trademark that's been essentially used, promoted, and advertised in Canada so that it has acquired a certain level of recognition in the market. That level of recognition is not necessarily clear. The cases that we've seen over the years by the Quebec court were about, I would say, marks that had been used for decades. So very substantial use. It doesn't necessarily mean that the bar is always that high, but those are the cases that we have seen in the past. It's very limited and burdensome for a business to rely on its common law marks, as we will see on the next slide. So, as I explained earlier, when a complaint is filed currently, and in the past, it's filed with the OQLF, and they will study the complaint, and then they find that it's warranted to send a letter to a business, be it a retailer or some other businesses. Once the letter is received, if the matter that is the subject of the complaint is a registered trademark, all that you need to do is take a copy of your certificate of registration and send it to the person at DOQLF that wrote to you, and that's going to resolve the matter essentially right there. So fairly easy process. Now, the thing that you need to understand here is that the OQLF is not the trademarks office, and it's not a court, at least not in the sense that we normally understand. So they're not asking you to show them that you've registered the trademark with the actual goods or services with which the mark is associated. It is about whether or not the mark is registered in your name or not. And that's all. So very simple. If you're not relying on a registration, then what's going to happen is that most likely you're not going to be able to resolve the matter with the OQLF. And the OQLF is going to pass on the complaint to essentially the prosecutor in Quebec, who may decide to launch an action against you and your business, a penal action. And then in the context of this court action, then you would have the opportunity to present evidence to show that you have common law trademarks in Canada, and therefore the trademark exception applies to your case. If, however, you don't succeed, you could be the subject of a negative judgment, you could be fined, but I would say those fines typically have not been very high. It's more about we would say the media impact that is significant. Now we have a question that is very relevant at this point. Who can file a complaint with the OQLF? Great question. Thank you very much. Anybody can file a complaint with the OQLF. So somebody that walks down the street, goes into a shop, sees something that they don't like, or watches a building with a sign outside, are very upset by the fact that it's English worded, they can file a complaint. And that's as simple as that. You know, you go to a shop to have your car repaired, everybody speaks English to them, they can file a complaint. I mean, it's literally anybody. So we can move on to the next. So in the context of the recognized trademark outside of a building, so that's something that 10 years ago was the subject of a court decision. Well, 10 years ago, the OQLF changed its philosophy with respect to that. It caused some stir in the industry. There were court decisions issued. At the end of the day, the regulation was amended. And so that what you need to do when you have a trademark that is recognized, displayed on a sign outside a building, you don't have to translate the trademark, but you have to have French inscriptions in a quantity that meets the criteria of the sufficient presence of French. So enough French so that a passerby understands what is going on in that commerce. You know, what is being sold there, what is being offered, what services are essentially being provided. And so what has been done by most businesses is to add some descriptive language, a slogan, or an indication as to the nature of the business, as in the examples that you see at the bottom of the screen there. All right.
So
Bill 96 and the trademark exception.
So thank you, Christian. Bill 96 significantly modifies the recognized trademark exception. As of June 1st, 2025, for both markings on product and public signs and commercial advertising, the exception will be restricted to registered trademarks only. So any common law marks appearing on a product or a public sign will have to be translated into French. In addition, for markings on product only, if the registered trademark includes a generic term or a description of the product in a language other than French, this generic term or description will need to be translated into French and will need to appear on the product or on a medium permanently attached to the product. As of today, we don't know exactly what it means to permanently affix the French equivalent of generic or descriptive terms without putting them directly on the product themselves. We maybe think of stickers that could be put on the product, but obviously it could be some other kind of medium. We can expect this to be addressed in a new or amended regulations and guidelines, which are not published yet. For public signs and commercial advertising, there will be a new requirement that non-French recognized trademarks that are displayed outside a building in Quebec be accompanied by inscription in French, having a greater visual impact than the trademark. And I will come back to this in a couple of slides, but just pausing here to this new generic and descriptive term requirement. If we read the new section 51.1 as added to the French Charter by Bill 96, but that will come into force only as of June 2025, the restriction only applies to markings on a product. Bill 96 does not specifically extend the restriction to product containers or wrapping or to any accompanying documentation of products. Whereas if we look at the current section 51 of the French Charter, as I mentioned before, the general rule applies not only to the product itself, but to their container or wrapping and also to the documentation accompanying the product. So in practice, what does it mean? Well, if we take an example, and the example I have in mind is a hand cream that I have here on my desk. So any word included in a registered trademark that would be deemed by the OQLF to be generic or descriptive of the product would need to be translated into French to appear on the product itself. So on the tube of plastic containing the cream. However, if the cream were to be offered in a packaging, so let's say in a box, technically, and again, subject to new regulation and guidelines that are yet to be published, the box itself would not have to comply with this new restriction, as containers and wrapping are not encompassed, as we can see, by the new upcoming section 51.1. Again, talking about generic and descriptive terms, what does that mean exactly? Well, we don't know how the OQLF will interpret the terms generic and descriptive in this specific context. It may be a term that is the name of the product itself or that describes a feature of the product. In any event, we hope that the interpretation will be very restrictive. So let's take another example. Of a registered trademark, that would be the brand of a name brand followed by the wording high definition, and that would be used in Canada in association with television. And maybe for the sake of the example, Christian, we can think of an actual brand selling televisions in Canada, if you don't mind.
Well, you can think of Samsung, LG,
so
Sony.
So let's take Sony. So if the trademark, again, for example, Sony high definition is marked on the product itself, is marked on a television, it's reasonable to think that the term high definition included in the mark, it would have to be registered, of course, would be considered to describe a feature of the product, that is a high definition television. So in that scenario, the high definition portion of the trademark would have to be translated into French, and the mark appearing on the television would be Sony Haute Définition. Also in Canada, a trademark that is clearly descriptive of the character or quality of the goods, which normally would not be allowed to registration, can be registered pursuant to the Trademark Act if it can be shown that the mark has acquired distinctiveness through use. As such, the new requirement that generic or descriptive language in a registered trademark be translated into French could potentially require the entirety of a registered trademark to be translated into French. For non-French recognized trademarks that are displayed outside buildings in Quebec, the current sufficient presence of French that under the actual regulation that Christian already mentioned, so that French language must appear on the sign or nearby describing the nature of the business, will be replaced by the more burdensome markedly predominant requirement. As I mentioned before, this implies that French language must have a greater visual impact than the text in the other language. And I think the key element here to keep in mind is twice as large. So Christian, now to you.
Thank you, Francesca. We have a number of questions that came in. So before we talk about how to prepare, I guess we'll address to a couple of those questions. So thank you. Keep them coming. So somebody's asking about if you walk in a shop in Quebec, do the employees have to address you in French? And is it okay to speak to you in English? And the answer is you need to be addressed in French. And if you want to speak French, they need to be able to speak French. And if they don't, then it's a violation of the charter and the shop could be the subject of a complaint. You agree with that, Francesca?
Totally.
And in addition to that, just for you to know, we said that Bill 96 brought a lot of changes to the charter of the French language. It also amended a number of other statutes in Quebec, including the Charter of Right and Freedom, such that it added a section to the Charter of Right and Freedom to any individual who lives in Quebec to have the right to live in French. And so an individual who walks in a shop and is serviced in English could not only file a complaint, but actually sue the shop for violating his or her rights. So that's something to keep in mind. Now, somebody else, to go back to your example, Francesca, is asking, is high definition permanently affixed to the TV?
In my example, yes.
All right, so that's what I thought. And then somebody's saying, well, you know, very nice to have registrations in Canada, but with CIPO having delays of almost 4 years, is it okay to tell the OQLF we only have a pending application and blame it on CIPO? What would you say to that, Francesca?
I say that you will be answering that specific question in the upcoming slides.
Yes,
but no, it's not okay. It's not
gonna fly, essentially.
It's not gonna work.
Now, somebody's saying high definition could not be registrable. That's right. But in the example that you provided, it was the brand of the actual TV, the house brand that was combined with high definition that were registered.
The whole mark.
Exactly. Now, somebody else is asking, what if a bilingual version of the mark is used and they have French registered? Using the two versions, is that okay?
Well, I guess it would be, I guess it would be okay to use both versions, no problem, but...
Well, you're using the French and the English together, so that's not a problem, right? So I'd say that the answer to that question would be exactly that. Now, somebody's asking about invented words, abbreviations. Are these the subject of French requirements? Well, the answer to that is that if it can't be translated, then you don't have to translate it. So then the answer to your question is no, you don't have to translate invented terms that are not terms consisting of combined existing words, but really made up words. All right, so I hope that answers the question. I'm sorry, I'm reading. There's many questions coming in. So the hand lotion that the example of the hand lotion is an interesting example because somebody's asking, well, do you need the French and English on the lotion bottle only? Well, the requirement is that French appears everywhere. We're talking here, French appears everywhere. English can appear together with French as long as French is equal or predominant over the English. But specifically referring to the trademark itself, if the trademark is on the bottle in English, that's fine unless it contains generic terms. Now, the challenge with the bottle example containing a liquid is an interesting debate that Francesca and I had. Section 51 used to say the product, its containers, or the packaging, but as we all know, a liquid, a cream, or a gel cannot be sold as is to consumers. It needs to be inside of a container. And what we're telling you is probably the way this is going to be interpreted is that the bottle or the container, in the eyes of the OQLF and the legislator, is probably considered to be itself the product. All right. So in these examples, the product is the actual container with the liquid or the gel or the cream inside. Somebody's asking, public signage, how is visible from outside interpreted? Does it include signage inside the building but visible on the street? Do you want to take this, Francesca?
Yeah, sure. So public signage is
on a building, right?
Yeah, on a public signage on a building. It has to be, I think, Christian, it has to be a passerby needs to see it.
Exactly.
So on a building, yeah, it would have to be at the exterior face of the building. Could it be,
or inside, but behind a window,
but behind a window.
See it from the street. That's the test, right? All right. So I think we've addressed most of the questions, so we can move on with how to prepare. So get your marks registered. And again, as I said earlier, yes, there's multiple challenges with CIPO, the Canadian Trademarks Office. We're well aware of them. So first of all, as I said earlier, you need to get your mark registered, but you don't necessarily need to get your mark registered for every single goods or services to which the mark is associated. So with your pending applications in Canada or the applications that you're going to be filing, what you need to think about is, can I adopt the pre-approved descriptions from the Goods and Services Manual for all of them? And I would say if you have a long list, it's probably not possible, but that doesn't mean that you have to drop it there. What you could do is definitely adopt some of the description in the Goods and Services Manual, and then divide out those goods and services from your application so that you can get a registration as fast as possible for those. So that's something to bear in mind. Also, there's a possibility to get expedited prosecution, and we're talking about here getting an examiner's report or an allowance, a publication notice within a matter of weeks in cases where you have an infringer, in case where you have somebody that is using your trademark on marketplace. So, and in cases where you want to be able to use border measures, but you need a registration to do that because somebody is importing goods or services, importing goods, in Canada, that would infringe your trademark if it were registered. Those are scenarios where the Canadian Trademarks Office will entertain the possibility of expediting prosecution within a matter of days to a few weeks. So that's very efficient. And I would say that's something that definitely needs to be considered. Also, you know, some businesses have very, very extensive portfolio. And so we encourage you to review the portfolio and identify trademark that are registered or pending that contain non-French wording that could be considered descriptive or generic. Again, here, this is more specific for products, the generic and descriptive issue. And again, as Francesca said, descriptive is like high definition for a TV. Generic would be like TV would be the generic term for a TV, just for you to understand. But again, the specific interpretation will be able to know more when we get the regulations and the guidelines. Now, you want to do this now and perhaps identify the clear-cut cases, the black and white cases, and then do a second review when we get the regulations and the guidelines to ensure that you're not missing anything in there. Then what you need to consider is potentially, you know, adopt alternative language for your descriptive terms and expression or generic terms. But before you get there, what really you need to determine is that going to be subject to this prohibition that Francesca described? Remember, for products, it has to appear on the product itself, with the caveat that for liquids and gels and creams, the actual product will be considered most likely the container, but not the box. So when it appears, when you've confirmed that the actual mark that contains generic terms or descriptive terms appears on the product itself or on the products themselves, then examine whether or not you have to translate those terms and how you're going to proceed to doing that. But there are also other options to consider because, as we will see on the next slide, there are other exceptions currently in the regulation that could potentially apply to your case. And so one of those examples, or a couple of those examples, and we do realize that this would not apply to a bottle of hand cream, obviously, but if the trademark is inlaid, baked, engraved, riveted, or welded to the actual product itself, and the product is manufactured outside of Quebec and then imported into Quebec, then you may not have to translate that language. And then obviously this goes beyond the actual trademark or trademarks that appear on this, on what would be the subject of this exception. You also may want to consider other exceptions, and I believe, Francesca, there's another exception that we've been asked about that contains, I believe, software.
Yeah, there is an exception under the current French Charter for software. So any software, computer software, and including game software, must be available in French in Quebec unless no French version exists. So to the extent that there is no equivalent of the software that exists not only in Quebec but anywhere else in the world, there would be no, it would not be mandatory to translate any software content into French.
Thank you. We're getting some questions here, and somebody's asking, what do you mean by the mark doesn't need to be registered for goods and services in Quebec? What I meant by that is that if you're selling in Quebec for example, hand cream, but you've applied to register your mark with a number of different products. And let's say you obtain a registration for shampoo, but you don't have, your registration does not cover hand cream. What I'm saying is you have a registration for shampoo, therefore your mark is registered in your name, and therefore you can show this registration to the OQLF, and it's going to put an end to the complaint process, even if your certificate of registration does not target or list specifically the actual products or services being offered in Quebec that are the subject of the complaint. Now, we're being asked another question is how this would apply to a solid bar of soap. So my take on this is that this is not a liquid, a gel, or a cream, and therefore the actual product probably is the bar of soap in this case. But then again, that's our interpretation, right? We don't have the amended regulation and the guidelines that would say, that would probably be my interpretation in this case, but we'll be able to be more certain, hopefully, in a couple of months. Lots of people have asked us, when do we expect these regulations and guidelines to be available, Francesca? Do you have any idea?
Well, no, I don't. Hopefully before at the end of the winter, but we don't have any time frame for the moment.
What we know is that they are probably working on them. And as you know, we had elections about a month and a week ago. Government stayed that was in power before, that introduced Bill 96, remains in power. The minister responsible for the French language has been replaced by a new person. So we'll see, but we're expecting, hopefully, as Francesca said, that we'll get something in the new year, at least as quickly as possible. Now, something now targeting more specifically signage outside buildings in Quebec, instead of using an English worded trademark, perhaps something that you may wish to consider if it applies to your business is a logo trademark without any wording whatsoever, or as alluded to earlier, invented terms. If you have a brand like this and that applies to you, then you wouldn't be, the requirements and Francesca and I have described would not apply to your case here. And also important to note is that these new this elimination of the common law trademark triggering the trademark exception, nothing in the amendments suggests that it's going to apply to commercial publications. And commercial publications, by way of reminder, includes pamphlets, brochures, but also websites and social media. So we don't know, as right now, nothing suggests that these new requirements will apply to that as well, i.e. that the trademark exception will be restricted to registered trademarks only as far as the use of a trademark in that context is concerned. But we caution you to perhaps adopt the position that it may, by way of the amendments to the regulation, but we don't know as of yet if that's going to be the case or not. Now, before we go to the risks of not complying, we received another question, and we're being asked if the trademark exception does not recognize the common law trademarks, does this conflict with well-established federal law? So somebody's asking, is there a conflict between a provincial statute and a federal statute? And that's a very interesting question. one that the federal government does not want to answer right now. But do bear in mind that trademarks, common law trademarks, are not creatures of statute, and therefore they're governed from a constitutional standpoint at the provincial level. So don't know exactly what the answer to your question is, but I suspect that it's something that will likely be explored in the months and the years to come. So the risks of not complying with the French Charter. Well, as we said earlier, the fines are increased significantly, but bear in mind that typically the fines that have been issued by the courts have been on the lower side. What's the big change here is that for a second or a third, a triple, well, for a double, sorry, a subsequent offense, the fines are going to be doubled and potentially tripled. Each day that you're basically breaching the charter constitutes a separate offense. That is a huge change. Let's say you have your products displayed in a retail outlet, a brick and mortar store somewhere in Quebec. Each day, after the court renders its decision, each day that you do not comply is a separate offense, and the actual fine applies to you. Of course, as we said earlier at the introduction, the OQLF has greater power and can force a retailer, for example, to remove the goods from the store. And if that's not complied with, then the OQLF could turn to the court and essentially have the business fined as a result of that, and can also ask the court to confirm the injunction, and non-compliance would be a contempt of court. And so that's something to bear in mind. And of course, and we can't emphasize this enough, if a business gets a judgment against it that it actually breached the charter, typically it's published in the newspaper, and that's not good for the business in general. So with that, we are near the end of our presentation. I don't see additional questions coming in, but we can wait a few seconds to see if anybody has additional questions. We've had a good number of them
already. Yeah.
Would it be possible to get a copy of the slide? Absolutely. And as we said, the webinar is recorded, so you're going to have access to that as well. So unless there are other questions, well, what is left for us to do is to thank you very much for attending our webinar today. Please do complete the survey at the end, because it's very important for us to know what your thoughts are about this webinar, the content, and also what you would like for us to cover in years to come. With that,
thank you very much.
And everyone, and have a great day.
Thank you.
Bye-bye.